potential prejudice to Ms. Isha's client, we're going to allow her to retake the deposition. I'm going to limit it to an hour. As to Mr. Harrison and Mr. Holmes, only on the issue of whether or not, what evidence do they have that Southfield knew that that the other defendants were breaching their fiduciary duty. Also, we're going to allow her to do 3 requests for productions on this topic, Ms. Isha's clients, Southfield, to do that, and 3 interrogatories, which will need to be answered within, let's say, 14 days by Ms. Pettit's clients. We are also going to continue the trial setting to May 10th. I think the parties have agreed that this will be a special setting, Ms. Benson, and that they will agree that if we are back, hopefully not, in COVID threat level red in Dallas County, that the parties will agree to a 6-person jury. Is that all agreed to, Ms. Pettit?
Yes, Your Honor.
Mr. Tillotson?
Yes, Your Honor.
And Ms. Ish?
Agreed, Your Honor.
Okay. You guys are off for next week. Good luck with everything. I'd encourage you, I don't know if you need to file a stay at this point or not. It's your call, Mr. Tillotson, but and we will see you on the next one, okay? And just get me an order that clarifies all that, Ms. Pettit. Make sure the order says at the beginning that this will be heard, that this was heard on March 21st, 2022. Make sure you share it with Mr. Tillotson and Ms. Ish. Make sure you email it to Rhonda, and as well as he filed it, okay?
Thank you, Your Honor.
Thank you, guys.
Your Honor.
Thank you, Your Honor.
All righty. So did you get an answer on that, Ms. LaBeouf?
Doesn't look like she's back, Your Honor.
Okay.
Who's that person?
Is she even on the Zoom now? I don't see her. There she is. Okay. Ms. LaBeouf, we're ready for you whenever you're ready. Mr. Burns, what are you here for?
Your Honor, I'm here for the DWAP docket. I was having technical issues this morning. I apologize for that. But it was item 8 on the docket, DC 20-14546.
Let me see. I don't see that's on the docket. Let me pull it up real quick.
It might have been number 5 on the updated docket, Your Honor.
14546. Yeah, it is.
Yes.
What's going on with this one?
Your Honor, the plaintiff has no basis to oppose dismissal at this time, Your Honor. We think that the defendant is in prison now in Tennessee and that there's just not a whole lot we can do that the client wants to pursue.
All right. Well, great. Well, not great, but sorry, hasn't worked out better for you. But we'll go ahead and dismiss it, and you be safe, okay?
Thank you, Your Honor. You as well.
All right. Thank you. Ms. LaBeouf, we're about to go to the next hearing. We need to get you back. Mr. Herring, why don't you give her a call? Tell her this next hearing is going to be quite long, so I'd like to be able to get done with you guys.
Yes, I will call her right now, Your Honor.
Okay, we need to come back on because the next hearing could be quite long.
I'm sorry, Your Honor, I'm on hold. And it's not very good hold music.
All right, we're gonna have.
I got her voicemail, Your Honor.
Yeah, I apologize, Mr. Herring. We're gonna have to go forward with this other hearing. I'm not sure what, so you guys are gonna have to wait. I apologize.
I understand.
We're gonna go forward on DC 209893 Moss v. Princip. Council, make your appearances.
Royce Weston, Craig Capio for the plaintiffs.
Gene DeBose for defendant Bone.
Leo Park for non-party Google.
Okay, so let's go forward with today's, anything that was previously said on today's docket.
Yeah, Your Honor, I need to ask a couple of questions before we get started. As the court signed the order that you put in place last week that we sent over to the court on Friday, the 21st is the day that distributions are supposed to be made to the defendant.
Mr. Park, you guys were supposed to give me some kind of comments on that, and I haven't heard them. I haven't seen them.
Your Honor, the last I heard is that our client said that we can't stop the payment today in time. We need at least, I think they said a week. They could stop the next payment, the April 21st payment, but just in terms of timing, they don't have enough time to redirect those funds to a Google account store in the 2 days or 3 days since the hearing till now.
Judge, out of all due respect, we've never had any testimony of any representative from Google. The only thing we've had is statements from counsel. And again, the court went through a lot of pain and torture, so to speak, in terms of putting this order together. We'd ask that it be filed, that it be signed. And if we need to visit with Google or their representatives subsequent to the signing of this motion, we'll do that and try to accommodate them as best as possible. But if we can't get the order signed today, then
I'm going to sign it right. I'll sign it right now.
all right, Judge. Secondly, we need to get clarification on the availability of Brian Martin to testify. You had indicated at a previous hearing that both Holly Bone Martin and Brian Martin would be able to testify by Zoom. We want to make certain that we're real clear on what he will be able to testify to. The court ordered that a default judgment back on May 4th, 2021, and basically said that plaintiff's motion to strike judgment debtors Martin's original answer motion and motion for default judgment as to liability is granted. And so I think that the only matters that he would be able to testify to is testify as it relates to damages. And we just need to make sure we get that straight so there won't be any confusion as we go into trial.
So first off, I'm going to allow any witness who wants to testify via Zoom to testify via Zoom. So that I just want to make that clear. I'm doing that in every case. I'm going to do it in this case. And so I'm going to accommodate the parties on that. Mr. DeBose, what is the other, as to Mr. Senator or Mr. West's other point, what did you?
Which other point with respect to what Mr. Martin can testify to?
Yeah.
He will be testifying to a number of things. For example, his relationship with his wife as he was managing her channels, his history with her and knowledge about what was done. His memory is a great deal better than my client's. So it will cover all those kinds of things. So I obviously he can't testify about the judgment against him, and I don't think he's going to. But he is a witness to almost everything that's before the court, and to deprive.
So let me ask this. This is just kind of conceptually how this is going to work. So there's a default judgment against Mr. Martin in this case
That's the liability, correct?
as the liability. So how does that, on this particular case, if it was a car accident case or even like a fraud case, I would get all of that. But on this case where Ms. Bone is taking the position that she owns this how is this going to work in practice in terms of the jury charge? How would this affect the jury charge?
I don't see that it would affect the jury charge at all. The jury charge is going to be about Ms. Bone and her ownership of the videos and of the channel. And I don't think there's going to be any instruction with respect to Mr. Martin. I think in interest of not prejudicing the jury, the fact that order has been, that he has the judgment against him should not be mentioned to the jury. But when we get to the jury charges, he will be clearly omitted from them.
Well, Judge, that's the very reason I'm bringing this up. And he will not be omitted from it. I'm asking the court to make certain that the jury knows that he has failed to follow the direction of the court, and the court's held him in contempt, and has basically said that his liability in this particular case has in fact been established what liability we're talking about. There will be an issue as to whether or not this is separate or community property, as an example. And so there needs to be some sort of charge that it's presumed, not only presumed, it is in fact his separate property based on what the court has done in terms of striking his pleadings. There will be some charging around separate and community property and his liability. That's the reason I'm bringing it up right now.
I'm not sure about that. The testimony about, and there is going to be a family law issue here, whether Ms. Bone's activities fall within that category in family law, which states that people who do things, create things on their own, not income from a business, is exclusively the property of the person who does those creations and is not susceptible to any of the liabilities of the spouse. We won't, of course, go into the significance of that particular ruling, but I think we need a finding of fact from the jury on that issue, and maybe some instruction.
I agree that to Mr. DuBose as the part of this, which is that just because there's a default judgment against Mr. Martin doesn't mean that that should exclude Ms. Bone from asserting any defenses that she has. And so, and this is not a ruling, but it does, I'm trying to think through this, which is what makes sense to me is that we would just have a question as to who owned the property, because it's a claim that the claim is that Mr. Martin negligent or fraudulently transferred the property. That's the claim. Fraudulently transferred this property to Ms. Bone. So the question would be, would the default judgment, so the way I conceived of this is that there's two different questions. There's, did Ms. Bone or Mr. Martin ever own this property, and whatever the property is that we're going to deal with. And the second issue is, did he fraudulently, if he did he fraudulently transfer that to Ms. Martin? And so I agree with Mr. DuBose. It's not fair to Ms. Bone that she can't assert that she owned the property. But if she did, if it is determined that Mr. Martin owned the property at any time, then because there's a default judgment against him, then the issue of fraudulent transfer should be established. That's conceptually how I'm thinking about it. It's not a ruling, but I think is that kind of what you're trying to get at, Mr. West? Or
That's exactly right, Judge. if the court has established liability against Mr. Martin, then a part of that liability, so to speak, as relates to our pleadings, is a fraudulent transfer by him to Ms. Martin. Courts establish it.
You mean to Miss Bone?
Yeah, I'm sorry, to Ms. Ali Bone, right, Martin. And so if the court has granted us a default judgment as to liability, a part of that liability is associated with our pleadings, which we pled fraudulent transfer. And so that's established. And we've got the default judgment against him. Now, logically, and I've been thinking about this for a while, logically, if we have a default judgment against him for fraudulent transfer, then the question, I have one in my mind, and never addressed this before, what does the jury need to be able to know concerning the default judgment and the liability? We want to make sure we have an adequate charge on that. And she can assert whatever she wants, that's her right.
But, so I can see two ways of doing this, and then I'll hear from Mr. DeBose. One is that we just decide the issue, did Mr. Martin ever own any of this? And then that's all the jury decides. Did Mr. Martin ever own whatever the property we're fighting over, whether it's the channels? Did he ever own Wildcraft? Did he ever own these videos? You know, did he ever own any of this, the contested property? And then that's it. That's the only issue, because we've already had a default judgment. We wouldn't need to bring up the default judgment because all they're deciding is this issue. If it comes in, if we're not going to do it that way, then I think the default judgment has to come in. But that's just kind of my thought. Mr. DeBose, what are your thoughts?
Well, I think the whole thing comes down to who owned the channels, who owned the videos. And once you decide that, you know, if you decide that Mr. Martin owned them, then my client is up the creek without a paddle. But that's the one issue. And I don't know, you know, I think the charge conference here is going to be, we'll pare this down very carefully. And I don't know whether we would have it a decision as to Mr. Martin and a decision as to Ms. Bone with two separate charges. You know,
Mr. DeBose, it sounds like you for once, you and I are on the same page, which is good. It's nice to be on the same page.
No, you know, I think when it comes down to the jury charge, we're not going to have much difficulty, because there, as far as I'm concerned, there are only two issues in this lawsuit that we're going to try, and one is who owned the channels, and I guess it's only one issue, the channels.
Well, yeah, who owned the
Video.
channels, who owned the videos? I think that's,
Yeah, and
May I ask a question? The issue concerning fraudulent transfer, that's an issue that's going to be decided by the jury too. And again,
well, Mr. West, that issue's already been decided.
okay, all right. So then the question is what type of charge would the jury get on fraudulent transfer?
They shouldn't get any, I don't think, unless you're making a fraudulent transfer claim against Ms. Bone.
Yes.
Well, the reality is that two things. As relates to Mr. Martin, we're claiming that he fraudulently transferred the channels and videos also. That was in the original pleadings, all right? And so there needs to be some consideration. And again, the court has to take this into consideration.
Yeah, but let me ask you this conceptually, Mr. Wyde, I guess, since you're the one who kind of, how could Ms. Bone have fraudulently transferred? I guess I just haven't, how could she have fraudulently transferred something that was owned by Mr. Martin?
Well, but here's the deal, Your Honor. Mr. Martin fraudulently transferred it to Ms. Bone, and Ms. Bone is now fraudulently transferred it to Wildcraft.
Oh, okay. Yeah, that's a good point. Very good point there. Okay. That's I hadn't thought about that.
Is that void ab initio? Listen to me, void ab initio. I remember. So
Anyway, I think you guys need to think this through, because I agree with you that as to any claims that are against Mr. Martin, those issues have been decided by default judgment. And so I guess there's two potential links here as to the videos. One is the transfer from, you're right, from, I think that's been decided that if he owned this property, then if he owned the channels or he owned the videos, then was the transfer, and that's what the jury decides. Then the issue of whether or not the transfer to Ms. Bone was fraudulent, that's been decided by default judgment. But whether or not the transfer from Ms. Bone to Wildcraft was fraudulent, that would be something the jury would need to decide. I think that makes perfect sense. But is that everything we need to talk about today, or is there something else we need to talk about today? I know you have a million other motions coming up between now and trial.
We do have the motion for contempt, Your Honor, today set at 10 o'clock. Corey Campbell is on that. Okay.
But Your Honor, I guess just to finish the whole order, before we get to that, could I just say two more things on Google's part on the issues of the order, and then we can get to the contempt, or I can.
Okay, I thought you guys didn't have any issues with the order. Do I need to go? I need to grab the order if you have an issue with it.
Well, I guess this is the problem that Google's been having just generally. I guess I just want to reiterate the timing issue is that part of the reason we're having trouble with timing is that because the new order is only directed at the videos that were transferred from the old channel, splitting that revenue up and only freezing part of the revenue is another difficulty that Google doesn't know how long.
No, I was going to stop all transfer. It would be that entire channel. All of Wildcraft would not be distributed. That was what I was going to do.
Okay, that's much easier for us. The other issue is that we can redirect the funds. Again, timing is an issue, but we can redirect the funds. But that redirecting the funds by itself would not prevent Ms. Bone from going in and then changing where the next payment goes. So what we could do is every month check what the system is set up to do manually every month before each payment. But if we want her to give, the only way to prevent her from changing it in the interim, in the 30 days between each payment, would be to freeze her out completely, which is again a more complicated endeavor. I don't know if that's necessary. We're happy
my hope is that's not necessary, that we'll have a decision on this case before then. That's my hope. Okay, so let me go grab the order real quick. I'll be right back. Okay, so I'm just going through the order real quick. Okay, so I'm going to set this temporary injunction on, so I'm going to sign the order here. And the temporary injunction will be on April 4th at 10 a.m. And
Your Honor, that's our trial date,
The trial
or the
date,
day before.
yeah, I don't really have any other choice here. So
Your, Your Honor, we've filed a number of objections to this proposed TRO. And I can share the screen.
now I've looked at the objections on this case. I think this is fine.
Your Honor, I guess Google's concern is on the last page. It says that Google will not disperse the monetization revenue from the videos identified in Exhibit 1. And that's one of the points, is that it's easier for us if it's the entire channel.
Okay, let me, oh, you're right, it does say that. I'll just say from the Wildcraft YouTube channel. And then I'm not going to put it in the registry of the court, so I'll take that out as well. Okay, I've signed it and it will be sent in. All right.
and Judge, we're looking forward to, we'll continue to work with Michael Hirsch and his team as it relates to this issue.
Okay. All right, so what was the other? I don't have the contempt was set for today.
Well, Your Honor, we had set a notice of hearing on our motion for contempt and motion for sanctions against Ms. Martin for her actions after you orally granted the TRO.
Miss Bone, you mean?
I call her Ms. Bone Martin. but
Okay.
I'll call-
She will prefer to be called Miss Bone. That is her business
Just call her Miss
name.
Bone.
she's been doing it.
Her
for
name in
10
this
years.
lawsuit is Miss Bone, so just call her Miss Bone. It'll be easier too, because we already have a Miss Martin who's, I think, going to testify, so we'll just call her Miss Bone. All right, Mr. DuBose, were you ready to go forward today or not?
I have filed a motion for continuance. There are motions, there are aspects to this motion. It is a motion for violation of 3 violations of orders of the court, and seeking a sanctions. But every one of those motions every aspect is facially delinquent. And I have filed motions to dismiss each one of those aspects, and hearings have been set on those 4 motions. But the main thing is, you cannot expect on 4 days' notice anybody to respond to contempt charges. Normally one files a request for a show cause order, to which there may be responses, and then we get to the contempt itself. So
I
Everyone,
agree with Mr. DeBose this time. I think I don't want to hear it today. I think you need to do a show cause and give him an opportunity to purge the contempt.
Your Honor, I
I
also
think
thought a
with-
motion for sanctions.
Whoa,
too.
whoa, Mr. Capua.
I'm sorry, I thought you were finished, Your Honor.
I wasn't finished. You're usually good about that, so please don't do that again.
I apologize.
So what my thought is first off, I think that the TRO kind of deals with this issue. We're freezing this money. I don't see a reason to really deal with this any more than that. And so if you do want to show cause, do a show cause order. But we're almost to trial. Let's focus on getting this case ready for trial is my recommendation. So I am going to continue this. I'm going to require a show cause order to be signed, and let's get this case ready for trial. That's my feeling. So I appreciate it, guys. Anything else today?
No, Your Honor.
that's it, Your Honor.
Thank you, guys. All right.
Thank you, Judge.
We will see you on all these other motions you've set. And Mr. DeBose, I would encourage you to talk with the other side and see if we can just focus on what do we need to do to get this case to trial, as opposed to fighting over all this other stuff. I'd encourage both sides.
I'm not asking for those fights. They
I know,
brought them
I
to
know.
me.
I
And
know both sides. I'm encouraging you guys to. Do
I'm perfectly glad to drop all those emotions if there are not going to be any motions like that coming back.
I think that's fair. So good luck, guys, and we'll see you hopefully on the day of trial and not before. But
Well,
I will strongly encourage you guys to talk with each other on how this charge is going to look, because I do think it's very complicated, and we need to, before we start this trial, we should have some idea what the jury is going to be deciding. So I would urge you to kind of focus on that issue as opposed to all these other ancillary issues. Anyway, good luck, guys, and we'll see you on the next one. Ms. LaBeouf, are you here?
Yes, Judge. Sorry about that. I called my expert too to make sure
Okay.
uh,
What did you find out?
that we can agree to a special setting the week of June 13th, which I think means a June 14th start for us, correct?
It's whatever the Tuesday is.
Yeah, okay. Yeah, we can agree to that. We can make it happen. And we understand the caveat that if we're back at Code Red, we'll have a 6-person jury.
And
All right, Mr. Herring, are you there?
I am, Your Honor, and the defendants agree to that too.
Well, we got to do, well, thank you. We'll do this on the record real quick.
Yes, sir.
Rhonda, are you there?
She's on the phone, but yeah, there she is.
Yes, I'm here, Judge.
I just want to make sure you put this in the system that they've agreed to a 6-person jury if we're in code level red.
6-person jury if read. Got it.
Okay.
Yeah,
and that's
Hopefully
with
it will
you,
never
Judge.
be red again, but you just never know.
Yeah,
All right, let's go on the record on DC 209893 Moss v. Princip. Council make your, I'm sorry, DC 1818484 Vavanta versus Act. Council make your appearance.
Nicole LaBeouf for the plaintiff, Dr. Shalane Mabanta.
Wald Herring for the defendants, Your Honor.
All right, I think the parties have had a good discussion off the record, and they've agreed that this case, and the court has also agreed that this case can be moved from its trial setting tomorrow to June 14th. The court will specially set this, and the parties have agreed that if on June 14th, when this case is specially set, if Dallas County is in COVID threat level red, that they will agree to do a 6-person jury. Is that correct, Ms. LaBeouf?
It is, Judge, and just to confirm, that's you trying it, not a visiting judge,
Not a
correct?
visiting judge, correct?
Yes, that is correct, and we agree.
Mr. Herring?
Yes, Your Honor, we agree to that.
Okay. Anything else we need to chat about today?
Well, I would propose we reschedule our lengthy motion because we have a little bit of time.
Mhm.
And I understand from communications last night that Mr. Herring wants to call his expert. I think we would call ours. And so we can reschedule that maybe together with the permanent sealing order hearing that allows the requisite time to have run and I'll confirm all the Supreme Court stuff and that we've dotted every I. And so that'd be my proposal. We'll reset that very soon, but but make sure that we have enough time on the docket. And we took enough time today, probably.
Yeah, and also that you confer on these issues as well. So,
Okay.
Yes.
Yes, Judge.
all right. Anything else, guys?
No, sir.
Not from the defendants, Your Honor. Thank you very much for your time.
All right. Good luck,
All
guys.
right.
We'll see
Thank
you
you.
on June 13th, if not before that, or June 14th, if not before that.
Sounds
right.
great. Thank you,
Yeah.
All
Judge.
right, thank you. Bye-bye. Okay, I think our next hearing is